Securing a Landlord Tenant Board Order in your favor feels like a significant victory. You finally have legal recognition of what your tenant owes you. However, it is crucial to understand that this order is not a guarantee of payment. It is merely the first step in a potentially long and complex process of enforcing the order and recovering your due compensation. Many landlords mistakenly assume that an LTB order automatically compels the tenant to pay. This is not the case. The order is a means to an end, not the end itself. You may need to navigate the small claims court system, understand the intricacies of different enforcement mechanisms, and be prepared to invest additional time and resources. This can feel overwhelming, especially after already going through the process of obtaining the LTB order. However, it is important not to get discouraged. In this video, we will look at how to enforce a Landlord Tenant Board Order in small claims court, garnishing wages if you know where a debtor works, and other garnishments if applicable. We'll discuss what an examination hearing is and how that can benefit a landlord. Seizing land or personal property. How a collection agency can be a landlord's best friend, and how to warn others about the debtor. Before embarking on the journey of enforcing your LTB order, it's crucial to gather as much information as possible about the debtor. This is where your detective skills come into play. Some key questions to ask yourself are: where does the debtor live now? Where does the debtor work? Do you know where the debtor banks and specific branch? Does the debtor have any assets that could be worth money? What you know about the person or people that owe you money can help with the collection process. Transferring an LTB order to small claims court. The LTB itself does not have the authority to directly enforce monetary orders. This means you'll need to take the initiative to transfer the order to a small claims court. This process, though seemingly bureaucratic, is essential for unlocking the court's enforcement mechanisms, such as wage garnishment or bank account seizures. Before taking any enforcement action, it is always best to make outreach to the debtor to try and arrange a payment plan. If successful, you'll save yourself a lot of time, energy, and costs. If the debtor is uncooperative or really just trying to scam you, then move forward with your best opportunity for collection, or failing that, warning others about the horrible payment habits of the person. Transferring an LTB order to small claims court is a relatively straightforward process. It involves filing the necessary paperwork with the small claims court, along with the original LTB order and a completed application form. The court will assess the documents, and once approved, the LTB order becomes an order of the small claims court. This effectively elevates the order's legal standing, granting you access to the court's more robust enforcement tools. Once the order is successfully transferred, you can begin exploring the various enforcement mechanisms available to you through the small claims court system. In order to enforce a LTB order in small claims court, the landlord must know where the debtor lives, works, or has assets. This could include wage garnishment, bank account seizures, or even the seizure and sale of assets. Options to collect a debt owed. At small claims court, you have many options including garnishment of wages or bank accounts, examination hearing to determine facts and assets, or the seizure and sale of assets such as a car or a home. Monies you can garnish include wages or salary, severance, long-term disability through a company pension or insurance plan, savings in a bank account, and sometimes monies owed to the debtor from the Canada Revenue Agency. Examination hearing. If you don't know where the debtor has assets, you can move toward an examination hearing and ask financial questions that the debtor must answer. You do need to know where the debtor lives or some way to serve the debtor to do an examination. During an examination hearing, if the debtor fails to appear, refuses to answer questions or provide details, the judge can order the debtor be held in contempt and can be sent to jail or fined. Seizure of assets. If you know the debtor has property, a fancy car, or maybe they bought a house, you can file an affidavit and writ of seizure and sale for that asset. None of these enforcement actions are simple, and they will take some work on the part of the landlord if they are to be successful. Once you have an asset or employment confirmed, you will need to transfer your LTB order to small claims court using the small claims court online portal or by attending to a local small claims court and managing the process in person. I find for transferring your LTB order to small claims court, it is easier to attend in person. If you need assistance filling out the forms, the court staff can often help guide you but cannot give you legal advice. Note: small claims court can only enforce orders up to their monetary jurisdiction of $35,000. Take your LTB order to the local small claims court to have it certified and a certificate of judgment issued. You'll be asked to complete Form 20A, Certificate of Judgment, and a Form 20P affidavit for enforcement request. As of now, there is a $30 fee for Form 20A and a $68 fee for Form 20P, subject to change. You will need the Certificate of Judgment in order to do any enforcement of the debt. You'll also receive a small claims court file number which you will need for enforcement. Now you're ready to start some enforcement actions. Wage garnishment. We will discuss wage garnishment first, as it is usually the easiest route to collect from a working debtor. Wage garnishment allows you to legally deduct a portion of the debtor's wages to satisfy the outstanding debt. This method can be particularly effective when you have verified information about the debtor's employer and their income. However, it's essential to follow the correct legal procedures to ensure the garnishment is executed properly and ethically. The process typically begins with filing the necessary forms with the small claims court, outlining the details of the debt and the debtor's employment information. First, confirm the debtor continues to be employed by contacting Human Resources. Many HR departments will no longer confirm employment over the phone. Another option is to call the employer and ask to speak to the person, or, if it's a large company, simply look them up in the company directory. Once you confirm employment, obtain the correct company name and address for Human Resources. This is important. If the debtor works for a company with 150 stores, you want to send the garnishment to the head office and not the individual store in most cases. If in doubt, simply call HR and ask where to send a garnishment. You can complete the Garnishment Form 20E before going to the small claims court or while you are there getting your certificate of judgment. If the small claims court needs to print the form for you, there may be a small printing fee. The form can be easily completed in advance and brought along with your LTB order to the small claims court. The court will then issue a notice of garnishment, which is served on the debtor's employer. Ideally, you will know where your debtor lives, so you can complete this information on the garnishment form. This legal document instructs the employer to withhold a specified portion of the debtor's wages and remit them to the court, which will then distribute the funds to you. It's important to note that wage garnishment is subject to certain limitations and exemptions. Provincial laws dictate the maximum percentage of wages that can be garnished, ensuring the debtor is left with sufficient income to meet their basic needs. You may also be required to serve the debtor. If you don't know where the debtor lives, you can ask the clerk at the small claims court about filing a motion for alternate service as you believe the debtor is avoiding you or paying the debt. Types of substituted service could include leaving the documents with a relative of the debtor, mailing the documents to the employer, care of the debtor, or other ways you think you could reach the debtor. Before granting a motion for substitute service, the court will need to be satisfied that you have made serious attempts to serve the debtor by the prescribed methods before bringing your motion. Keep accurate records of how and when you have unsuccessfully tried to serve the debtor. Once you serve the garnishment to the employer is legally obligated to comply with the garnishment order. Be aware, there are some instances where a garnishment may not collect money for you, such as when a family court order is already in place, the Canada Revenue Agency is already taking funds, or a payday loan company is already taking funds. In addition, if there are multiple garnishments for commercial debts, the garnishment can only take 20% of the wages. Each garnishment would receive a portion of the monies garnished. Income you cannot garnish includes Guaranteed Income Supplement, Old Age Security, Canada Pension Plan, Social Services payments, Ontario Disability Support Program, and child support payments. Once the garnishment is in place, it is valid for 6 months. It is also a waiting game for the landlord. After 60 days, you can contact the small claims court to see if funds have been remitted from the employer. Be patient. It could take months for the small claims court to remit funds to you. It is beneficial to place a garnishment on the debtor's bank accounts simultaneously if possible. Unlike wage garnishment, you can get 100% of the funds present, as well as any new deposits they may be expecting in the near future. If you're lucky, the debt will be paid in full and you'll be a happy landlord. Examination hearings. Unveiling the debtor's finances through the power of an examination hearing. In the quest to enforce an LTB order, knowledge is power. An examination hearing, a powerful tool available through the small claims court, allows you to gain valuable insights into the debtor's financial situation. This hearing provides a formal setting to question the debtor under oath about their assets, income, expenses, and any potential sources of funds to satisfy the debt. If you know where the tenant lives, their parent lives, or have some other way to contact the debtor, but don't know of any of their assets, you could consider an examination hearing to learn more. Examination hearings are tricky, time-consuming, and often frustrating. The landlord would file a Notice of Examination Form 20P with the small claims court. You would also contact the clerk to select a date and time for the hearing. You have a bit of control. You must serve the form to the debtor. See the rules of service and the potential for substituted service to a parent or through other service methods. The debtor will be required to attend the hearing and provide a completed financial information document. Think of it as a legal and structured way to uncover hidden assets or income streams that the debtor might not readily disclose. During the hearing, you can ask specific questions about their employment history, bank accounts, property ownership, and any other financial dealings that could be relevant to the debt recovery process. You can also ask about personal habits such as smoking, drinking, etc. Ask why they have not paid the debt or made a repayment plan. Ask how much they can begin paying this month. Try to work out a payment plan. The judge may order a payment plan on certain dates. An examination hearing is difficult, and getting the debtor to attend is even more difficult. If the debtor does not attend, I would ask for a contempt of court order. You may not get it on the first attempt, but don't give up. Serve another examination hearing form and try again. If the debtor refuses to attend, you may get that contempt of court order and the debtor may face jail time. Seizure and sale of land. When other enforcement methods prove unsuccessful or insufficient, seizing and selling the debtor's assets may become necessary, including land or a home. This process, though often seen as a last resort, allows you to recover the debt by liquidating the debtor's assets and using the proceeds to satisfy the outstanding amount. However, it's crucial to understand the legal complexities and potential challenges associated with this enforcement method. The process begins with identifying the assets available for seizure. Seizing assets, whether land or personal property, requires obtaining a writ of seizure and sale from the small claims court, Form 20D, against a debtor in any county where a debtor may own land or a house. This writ would encumber any property the debtor owns now or into the future, where the writ is filed. This legal document authorizes the sheriff to seize and sell the debtor's assets to satisfy the debt. You can file more than one writ in different counties. A writ of seizure and sale of land can be very effective as it will be difficult for the debtor to sell or mortgage the land until the debt is paid. If more than one debtor has filed a writ for the seizure and sale of land, the monies recovered will be shared on a pro rata basis. Essentially, each party will get a percentage based on the value of the debt. Not sure if your debtor owns land or a house? Consider doing a name search at the land registry offices or online with Service Ontario. There is a small fee for the search, but it might be very worthwhile. Now, maybe you don't want to wait for your money and you want the property sold. What are your options? After your writ has been in place for at least 4 months, you can direct the enforcement office's sheriff to seize and sell the land. They cannot proceed until the writ has been in place for 6 months, but you might want to start the process early. You'd need to contact the enforcement office for the exact steps for your location to commence with the seizure and sale of land. Be aware that mortgages, liens, and other encumbrances on the property will reduce the amount available to be seized and sold. There will be costs incurred and a large deposit for the expenses associated with the sale. It's a complicated process and not to be undertaken lightly. Definitely get legal advice before trying to force the sale of land or a home. Seizure and sale of personal property. If you know an asset the debtor has, such as a fancy car, motorcycle, jewelry, or other asset, you can complete a writ of seizure and sale of personal property, Form 20C. The writ of seizure and sale of personal property expires after 6 years but can be renewed. This gives you some time to find assets. This is another big step, so I highly recommend obtaining a legal opinion from a qualified paralegal or lawyer to discuss your specific case. Once you know or suspect the assets of the debtor, you can complete the direction to enforce writ of seizure and sale of personal property form. This form is the detailed information needed to allow the enforcement staff to locate and seize the specific property. There is an enforcement fee before enforcement staff will chase down the goods to ensure you have all the details and the recovery is worth the costs. Costs could include things as freight, insurance, locksmith, storage, mileage, and advertising of the sale of the goods seized. Enforcement staff will seize and store the items until a public auction is held, at which time the goods will be sold. The enforcement office will calculate the net amount of proceeds from the sale, and the funds will be deposited with the court. After which, the net proceeds will be distributed to the creditors who initiated the enforcement process. Okay, you have options if you have a LTB order against a tenant and want to enforce that order in small claims court. There are many steps to recover your money, but there are also other options. Collection agency, a landlord's best friend. Now, while enforcing an order in small claims court can be very difficult, using a collection agency to collect is much simpler. If you find yourself feeling overwhelmed or lacking the resources to pursue the debt effectively, enlisting the services of a reputable collection agency can be a viable option. These agencies specialize in debt recovery and possess the expertise, resources, and legal know-how to handle the process on your behalf. Collection agencies act as intermediaries between creditors and debtors, working diligently to recover outstanding debts while adhering to legal and ethical guidelines. While you may not recover as much money as direct enforcement, it is much simpler to let the professionals handle the matter for you. A collection agency will take your information and all the information you have on the debtor. They will put the information on the credit bureau so anyone checking credit will know about the debt. This is beneficial as many financial institutions will require debts to be paid before they lend money, such as buying a car or a house. The collection agency will track down the debtor and call them to arrange a payment plan. They may also determine where the debtor works and discuss placing a garnishment on your behalf. While the collection agency will take a hefty fee for their help, anywhere from 30 to 50%, it gets the job done where possible. While this can seem like an additional expense, it's important to weigh it against the time, effort, and potential legal costs you would incur by handling the debt recovery process yourself. In many cases, the expertise and resources of a collection agency can significantly increase the likelihood of successful debt recovery. Personally, I find using a collection agency an easy way to collect some of what is owed. Be aware, if the debtor is on a social assistance program, there may be no chance of collecting. The best a collection agency can do then is post the debt on the credit bureau. Posting your order and the credit bureau. Consider protecting your fellow landlords and sharing information responsibly. Experiencing the frustration of dealing with a non-paying tenant can leave you feeling isolated and helpless. However, remember that you're not alone in this experience. Sharing information about delinquent tenants with other landlords while respecting privacy laws can be a powerful tool for protecting yourself and your fellow landlords from future financial losses. While a landlord cannot post their LTB order directly on the credit bureaus, they can use alternative services. I know it just seems wrong that tenant debt is not treated as seriously as a credit card or even a cell phone debt. A landlord can use a third party to post the order, such as single key. Warning other landlords about the debtor may also be a consideration, in which case there are a number of sites where a landlord can upload an order. This video, its authors and affiliations makes no warranties or guarantees regarding the services or legalities of these businesses or sites. Sites a landlord may consider include OpenRoom and Landlord Easy. Canly is also a government searchable site of which landlords should be aware. Unfortunately, Canly only posts a fraction of LTB orders, and it does not seem to be timely. While a landlord has many options to attempt to collect a debt from a past tenant, none are easy. Many tenants will go out of their way to avoid the debt and make no attempt at repayment. If a tenant files for bankruptcy, your entire debt could be wiped out. Why stealing rental services is not considered a crime, no different than stealing a jacket from Walmart, continues to befuddle me. Alas, this is the system we have. Enforcing an LTB order is rarely a straightforward process. Debtors may employ various tactics to avoid their financial obligations, leaving landlords feeling frustrated and uncertain about their next steps. Let's explore some common challenges landlords face during the enforcement process and discuss practical strategies for overcoming them. One common scenario involves debtors who disappear after receiving an LTB order, making it challenging to serve them with legal documents or initiate enforcement actions. In such cases, conducting thorough searches using public records, online databases, and even social media can help locate the debtor's current whereabouts. Wishing all landlords much success in recovering owed monies. Please like and subscribe to support this site.